All right. Well, hey, let's go ahead and get started. We'll have some more folks coming in. First and foremost, I want to introduce myself. My name's Clint Brown. I am a shareholder with Roberts, Markel, Weinberg, Butler, Haley. And I'm going to be speaking with Mary Shiloh on bankruptcy basics. Mary Shiloh is board certified in bankruptcy law. She's one of the few paralegals in the state of Texas that is board certified in bankruptcy law and works for a creditor's law firm. So we're very fortunate to have Mary on our team. And Mary and I are going to be talking a little bit about kind of bankruptcy basics, the bankruptcy 101s that you as a manager and or board member need to know about when a debtor or an owner files for bankruptcy protections. So first and foremost, y'all probably know this, but this is a certified presentation, which means you will get a 1 hour of continuing education credit. And Mr. Beam and the marketing team will be providing those certificates to y'all after the meeting today. And then number two, as Mary and I kind of go through this presentation today, if there are any questions, please kind of type them into the chat. And Mary and I will leave about 15 minutes for this hour presentation for Q&A. So let's go ahead and get started. All right, so I'm an attorney. Mary's a paralegal. Got to give our legal disclaimer. The information presented today is based on the law as it exists today, February 7th, 2023, and it's presented for educational purposes only. It is not legal advice. I understand there may be some hypotheticals that get thrown at Mary and I, which is okay. Just know that it is not legal advice that we're going to be chatting about and giving responses on. So if there is a legal question, we encourage you to please reach out to your attorney, your association's attorney. All right. So here's the overview that Mary and I are going to be hitting on today. So we're going to talk about the automatic stay, what that means for you as a creditor, as a community association. We're going to talk about the statutory provisions and lien stripping for accounting, splitting hairs and accounts, how to split the account properly between pre-petition and post-petition, what pre-petition and post-petition mean, why the flag or hold on an account that is with management is so important for bankruptcy and for our law firm. And then for managers, we're going to talk about kind of notice letters, whether to send or not to send when an owner is in active bankruptcy. And then finally, for deed restriction violations in an active bankruptcy, what can we do to try to get the violation cured? We're also going to discuss the proof of claim, what that is and what it does to protect communities and the amounts due and owing. And then finally, the distinction in bankruptcy between a dismissal and a discharge. All right, the automatic stay is brought to you by Section 362 of the U.S. Bankruptcy Code. What is it, Ms. Shiloh?
It is an absolute stop sign. It is an absolute roadblock. And so technically it's a federal injunction staying any act to create, perfect, or enforce any lien against any property of the estate. Now, what's particular about the estate is where you have a foreclosure posting on a property, and then you find out that the wife filed the bankruptcy, but the house is only in the husband's name. And the question is, can we still foreclose? And the answer is no. The stay affects the absolute property of the estate, and this can also count for tenants of a property. Now, Now, the issue is who gets a stay? So, you know how we get these frequent flyers, these people that come in and they file bankruptcy so often and they get dismissed and then they file another one. Well, there were reforms put into place in 2005 called the Bankruptcy Abuse Prevention and Consumer Protection Act, BAP-CPA. And what that reform law provides is that when a person is in a bankruptcy and it's dismissed, and then within a year of that bankruptcy becoming dismissed, if they file another bankruptcy, they have to go to the court and they have to ask for permission to have an automatic stay. Now, if they file two bankruptcies, they have two that have been dismissed within a 1-year period from the current bankruptcy, there's no stay. However, there are contractual conditions that apply, and Clint can explain this better than anybody, where if the HOA is listed and scheduled in the Chapter 13 plan.
Perfect. All right, so Mary, you want to go into a little bit about limitations on an owner filing bankruptcy, because a lot of communities kind of deal with this situation where Bob, the owner, files bankruptcy to avoid some sort of legal action by the association. 2 months later, it gets dismissed. Then Bob files bankruptcy again when we try to initiate legal action. How does 11 USC 362 help the association or just the bankruptcy code in general?
So it's very frustrating. I'm sure, as you all know, when you've been through it, and it really can get board members upset because they want to say, this is crazy. How many times can this person file bankruptcy? Well, unfortunately, that's not the structure of it. It's not how many times they can file. It's where are they in the filing process, as far as were they in one bankruptcy and then they didn't make their payments. That's the most common reason for a bankruptcy to be dismissed. They weren't making their payments and then the court dismissed it. And then it came right back through the collections or foreclosure process. So they filed another bankruptcy. So that time period between when the dismissed case was thrown out, dismissed, and when the new case was filed, if that is a 12-month period within which that occurs, then when they file the new case, they have to ask permission for a stay. And there's a very specific rule in 11 USC section 362C3, which provides that not only do they have to request it from the court, but it has to be finalized within 30 days of the date that they file bankruptcy. Then below that is 11 USC 362C4, which provides that if 2 or more bankruptcies were filed in that 12-month window, that there is no stay. There's no stay, and technically everybody can move forward. So if the mortgage has it posted for foreclosure, they can technically go ahead and foreclose. Now, there's all kinds of scenarios, possibilities. We're not suggesting anybody take any action based on this information. We're just outlining these are the parameters. And then as well, sometimes a mortgage, we had this happen recently in one of Clint's cases where a mortgage did actually foreclose and then the debtor filed bankruptcy an hour later. Seriously, an hour later. And so then the mortgage had to come in, go through the judge, and have the judge enter an order in rem or against the property only, stating that the foreclosure was good. So there's all different kinds of possibilities. Please consult your counsel when you're looking at anything like this. Don't try to make any presumptions.
And so the takeaway from Mary's points is when you're dealing with a homeowner that files bankruptcy over and over and over again, there are some stronger remedies the association may be able to implement to protect its lien rights and potentially foreclose. And I say potential and may, because to Mary's point, there are so many exceptions in the bankruptcy code that you have to be aware of, because what Mary just went over is the general rule, but there's always ways around it that the debtor may be able to reactivate the stay, even though it's not in place on the day that Mary and I look at the file. So it's very important that you get counsel from the association's legal counsel in making the decision on whether or not to kind of proceed with that collection action. But know that there's something you can do. You don't have to sit on your hands when you're dealing with what's called a serial bankruptcy filer. All right, so communication, Mary, management or the board gets a phone call, gets a notice, something from the debtor / owner. What should happen?
So in any event where someone calls, faxes, mails, emails, texts, any kind of notification, hey, I filed bankruptcy, they are required to tell you the case number, the district they filed in, and the date that they filed, and their attorney's information if they have one. And that's it. And then beyond that amount of information being communicated, you don't talk to them further. You don't ask them any questions. You don't say, are you keeping your house? You don't, nothing. And then you notify your counsel of that bankruptcy case number. Sometimes the district of filing is important if you have associations all over the state, which many of our management companies do, and that you flag the file as bankruptcy, mark it, and know that you've got your counsel retained. In other words, just because you've notified your counsel doesn't always mean that they have opened it up, they're taking it on, and they're protecting your HOA claim rights. So make sure of that. Then following that, the regular notices that you may receive if you're on the court, what's called BNC noticing matrix, if you get regular mail on the bankruptcy, the important things, there's really two that are most important. Number one is an objection to the HOA claim. Now, you may see an objection to a claim come in, and it may be on the mortgage, or it may be on the auto loan, or it may be on the water softener, or it could be anything. What we're concerned about, obviously, is any objection to the HOA claim. The second one is any intention to strip the HOA lien. Now, sometimes it's called lien strip notice. Sometimes it's called notice of intent to strip lien, notice of intention to strip lien. These are things that you would need to notify your counsel of immediately. Even if your counsel already has this account open, they know about the bankruptcy and they're monitoring it and what have you, but you must provide those because for those two, especially, there's a very short window of opportunity to object to it, to fight the claim, to defend the claim, and make sure that we don't get zeroed out.
So to Mary's point, I'll talk a little bit about our office and what we do. So Mary and her team gets notified of a bankruptcy. One of the first things we do is file what's called a notice of appearance. After we've given counsel to the association, tell them the stop sign's in place, flag the account, don't do anything. But when you get those two documents, either a notice of intent to strip HOA lien or an objection to the HOA claim, it is important to provide that to your counsel, because while they may have filed a notice of appearance, sometimes the notice does not get delivered to counsel. And so it's a belt and suspenders approach. Why is that important? Why are these two documents so important? Because if we don't file a response within a short time frame, and it's 28 days, we may not get our lien paid at all. It may get stripped or wiped or just not part of the confirmed plan. So when you see those two document types, get them over to your counsel so that they can look at it and provide advice if it's something that needs to be fought. All right, so what's this splitting hairs and accounting, Mary? How do we split hairs properly?
So The frustrating part about this for all of your accountants out there, and we are so blessed to work with some of the greatest accountants ever, and very patient, which you have to be to deal with it when it goes through a bankruptcy. But what we like to advise is to always start out splitting the account if your system allows you to do so at the petition date. So what that means is the actual date that they file the bankruptcy, we want you to stop your account and note that as the pre-petition account. Some managers like to call it the 99 account or the bankruptcy account, and that's fine. However you want, whatever nomenclature is fine, but we would like you to split it so that you can keep it separated. The number one reason we ask you to split it, if your system allows you to do so, is so that your system will not automatically generate any statement and mail it out to the homeowner, including any amounts that are part of the pre-petition balance, because that is a direct and egregious violation of the automatic stay. This is the number one culprit where we come in and Clint gets a client that accidentally, their system did that. They didn't mean to. It certainly wasn't willful, but Clint has to come in and represent them in defense of a lawsuit because debtors can make money suing their HOA and other creditors for doing such a thing as sending out a statement with the pre-petition amount. And that's scary. And it's real. It's very serious.
So before we get into lien strip, just a quick kind of example for Mary's comment. So let's assume we're dealing with an annual assessment association. So the assessment comes due 12:01 a.m. on January 1st of every year. 12:01 a.m. the 2023 assessment comes due. At 12:15 a.m. on January 1st of 2023, an owner files bankruptcy.
Yeah.
So from that date backwards is pre-petition debt. So because the assessment for 2023 came due at 12:01 and they filed at 12:15, the 2023 assessment is part of the pre-petition debt. And again, if the account's with our office, Mary's going to assist in splitting the account if there are questions, but that's basically the cutoff. So backwards pre-petition, all new amounts that come due and owing after that petition is filed are going to be post-petition debts. Well, Mary, here's a question for you. What about interest that relates to a pre-petition assessment? What do you do?
No. So as part of, I'm so glad you brought this up, because as part of marking, flagging, halting on the bankruptcy account as of the petition date, there's one more thing we have to do. We have to reach over to the faucet on the side of the house and turn it off, because the interest cannot continue to run. It's going to mess up your accounting. And if it bleeds over into your post-petition account where you have everything separated, it's going to create another opportunity to have an allegation that we violated the stay.
So the court determines interest. We don't get to determine interest based on our documents. The court does, and it's based on a court case, TIL, and it's basically prime plus. And we may be able to get 1 or 2% points added to our interest rate, but ultimately the court gets to decide what our pre-petition interest is. That's why that faucet has to be turned off, because it's going to cause a big mess otherwise.
And it's kind of weird how it's been working out lately, especially the last couple of years. We can be included for interest in a Chapter 13 plan anywhere from 1.25% to 6.25%. But for those of you managers and accountants that have communities in the Western District of Texas, like where Clint is, Austin, San Antonio, that whole Hill Country area, generally, 0 interest is given to the HOA. Now, is it something we can negotiate? Possibly. Are we going to win? Possibly. But again, if we go through the process, but the bankruptcy ends up getting dismissed, it's going to go away anyway, and we'll be starting over under your regular contractual governing documents.
Yeah, and let's just talk money, right? So
Yeah.
let's say if we got our interest, we were talking about $300, $400 in interest. Is it really worth spending $1,000, $2,000 in attorney's fees? No, of course not. So that's why you don't see a lot of homeowners associations push back. Is it fair? No, it's not fair. But I think the Western District recognizes the fact that they're not going to get pushed back too much on it, and they take advantage of that situation sometimes. And it is what it is. And if I've ever got a client who understands the fact that they'll probably never see those attorney's fees again and still wants to push, well, then we can push. But most of the time it's our recommendation to just leave it alone. Because to Mary's point, if the bankruptcy gets dismissed, we get to charge back all our interest anyways. And we'll talk about dismissal versus discharge in a little bit. Let's move on to lien stripping. What is it? So first and foremost, it is only in Chapter 13 bankruptcies, and it only occurs when the house is upside down. General term of art in the real estate industry, when your house is upside down. What does that mean? It means the fair market value is less than the purchase money mortgage, right? Your loan plus taxes. And it may include equity loans, but that's more governing document dependent, and it's nothing for y'all to worry about. But the general rule is fair market value is less than the loan for the purchase of the home plus taxes. When that occurs, the house is considered upside down or underwater. And when that activates, the debtor, through their counsel, can basically file a notice of intent to strip the association's pre-petition lien. So let's go through an example. We've got a home that is worth $100,000. Fair market value is $100,000. And I know that's not really any homes in Texas anymore. But for just example purposes, $100,000. And then the first lien, the loan is 105, and the taxes are 5. So the amount due and owing on the home is 110. The house is only worth 100, so it is underwater by $10,000. That means they can strip our lien and wipe out the money due and owing the association. Now, here's the thing that Mary and I fight over. Here's what we fight over, and it's the fair market value. Number one, and then number two, it's something Mary catches a lot, and it's called double dipping. It's when the owner basically includes the mortgage amounts twice, the delinquency amount plus the total amount that the mortgage is alleging they are due and owing. So that's called double dipping. Mary gets with debtors counsel and basically says, hey guys, y'all are double dipping. Y'all want to clean this up, or are we going to have to fight it and bring it to the court? Sometimes Mary's able to get it resolved without having to file anything. Other times we've got to file something with the court and say, hey, judge, they're double dipping. The other argument that we make is fair market value. This one is a much more difficult argument to make because we have to get an expert up on the stand, an appraiser that says, hey, based on my experience, the fair market value isn't this, it really should be this. And there's direct questions that we get to ask, and then the debtor's attorney gets to cross-examine. So again, Mary and I will look at this. We may say, hey, you know what? It's worth filing a response, but it's not worth going to a hearing on. Let's make a deal. And it's not worth going to a hearing on because you've got to pay the appraiser $750 and you've got to pay me $1,500 in attorney's fees to go to court and argue to a judge for 2 hours. So all things your counsel is going to advise you on. And then finally, the thing Mary and I hit on earlier, your response time is 28 days. That's why it is so important to notify your counsel when you get one of these lien strip objections. It'll say lien strip in there, and it'll mention the association's name in the body of the notice of intent. When you see that, get it to your counsel ASAP. So this kind of goes into lien stripping a little bit more. Mary, why should, okay, so Mary, let's go through a hypo. They're successful in their lien strip. Should the association write off the pre-petition amounts due and owing?
No. Wait. Because the parameters and the structures that are required for a lien strip to be fully finalized, memorialized, executed are hefty, okay? Number one, the homeowner has to stay in that Chapter 13 bankruptcy plan and complete it, which means they have to make all their payments, and at the same time, all the post-petition years that accrue while they're in that bankruptcy, they still have to pay. Okay, so don't misunderstand when we say lien strip. We don't mean a removal of a lien. We mean a stripping of a lien for the pre-petition period only. So post-petition, every year's assessment still accrues, still due and owing. Then not only do they have to complete the Chapter 13 plan, they have to be recommended for discharge by the trustee. They have to file a formal certificate of credit counseling. They have all kinds of bells and whistles that they have to perform. Then they have to receive a Chapter 13 discharge. They cannot convert to like Chapter 7 or something like that and get a discharge and have a lien strip extinguished, No. They have to receive a Chapter 13 discharge.
Perfect. So again, even though the lien strip may be successful during an active bankruptcy, your counsel should advise you to not touch the pre-petition account and leave it alone. Because again, if there is a dismissal, then it's like the bankruptcy never happened and we get to collect all those monies. So keep that in mind. All right, Miss Shiloh, what happens if you violate the stay? What?
It costs you a lot of money and it's totally preventable. So all it takes, honestly, is one demand letter or one account statement that has all the amounts. All you have to do is mail that to the homeowner, and that can constitute a violation of the stay. Now, it doesn't matter if you didn't keep a copy of it because it went out and they had it and they received it. And even if it wasn't sent certified, or even if it wasn't some big burly guy at the door saying, rah, 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 here's your demand, it's still a violation of the stay. And so, again, like we spoke about earlier, in splitting those accounts between pre-petition and post-petition to ensure that no statement goes out is vital. But also, if you're going to send a post-petition statement out, you cannot make a demand or threaten action. Now, what does that mean? Well, you know how some of the 209 language says, first of all, we could foreclose your lien. Second of all, in the event of, referring to legal for collections, you will be made responsible for those legal fees. Can't say that either. So none of the 209 language is acceptable for any account that's in an active bankruptcy, even if it's for post-petition amounts. Similarly, with deed restrictions, and I think Clint's going to mention that in a little bit. Deed restrictions, again, The problem is don't make demand and don't threaten action. That's what keeps us safe.
Perfect. So as Mary kind of alluded to, the automatic stay, that cause of action, it's considered what's called a strict liability statute. It really doesn't matter whether or not you knew of the automatic stay, because all they have to do is prove up two elements. Number one, when you sent, or actually three, number one, was there a demand for payment of amounts that are protected by the bankruptcy? Number two, was that demand issued when there was an active bankruptcy? If the answer is yes to number two, you move on to question number three. Did the association have notice of the bankruptcy? It doesn't matter if it was on your desk. It doesn't matter if it was at the attorney's office. It doesn't matter if it was at management's and we just haven't gotten to the mail yet. If we had notice, were provided notice of the bankruptcy, that's it. Nothing else matters. It is a violation of the stay, which entitles the debtor to file a lawsuit against the association. Now, what are the damages? Well, there's mental anguish. So the owner, mentally was worried about foreclosure, and those damages are typically less than $1,000. Not much in the scheme of things. But what 11 USC 362 also gives owners the right to recover are attorney's fees. And unfortunately, bankruptcy attorneys are very, very, very expensive. And if you don't resolve the case quickly, you can easily get into the $5,000, $7,500, $10,000 range on attorney's fees. And some of these attorneys like to hit the file hard to get those attorney's fees up. So it's imperative that if there is a violation and a lawsuit is filed, you stop it as quickly as you can, because most of the time there's not a good defense we get to raise. Sometimes there is. Don't get me wrong, and your counsel is going to be able to look at that. And then the other thing to think about is insurance coverage. A lot of policies don't cover bankruptcy violations. Some do, and if they do, your defense counsel can get involved. But a lot of times there is no coverage, which means it comes out of the association's pocket. So it's imperative to get that thing resolved as quickly as you can.
And it looks like, if I could jump in, looks like somebody brought up a really good point. It's not only what is costing your association for its own legal fees, like for Clint to come in and defend and represent. Many times the judge, actually, I guess every time, if it goes to judgment, the judge will order the association to also pay the homeowner's legal fees.
Right. Yeah. Yes. So
Yeah.
they're entitled to their own legal fees. Yeah. So it's kind of, you're having to pay two attorneys. You're having to pay the owner's legal counsel, and you're having to pay your own legal counsel. So it's a situation you do not want to be in.
Plus the sanctions, plus the fines.
Right. All right. Sorry, we're talking about all this doom and gloom. All right, account splitting. Mary went into this a little while ago, but this kind of makes it concrete. Amounts up to the petition date, so up to January 1st, 12/01 of 2023. That amount backwards is considered the pre-petition account. Stop all your interest. Credit all trustee payments. Apply it to the pre-petition account. Do not apply trustee payments to post-petition. That gets you in trouble. Unless Mary tells you to.
Yeah.
What's the exception to the rule where you can apply trustee payments to post-petition accounts?
So it's called HOA reserve, and I like to think that we have a lot to do with it. All of our awesome communities in Texas. It was kind of a push that we started, I would say, in 2007. By 2017, the Southern District of Texas put into play, and they changed the plan form. All the judges were involved and everything, and they changed it to include a special provision. It's provision under Section 23 of the Southern District Chapter 13 plan form for HOA reserve. What that means is when the homeowner, when their money gets pulled out of their paycheck by the trustee for the plan, then part of it gets put over in a reserve account, generally one for the HOA and one for the taxes. And sometimes there's some additional layer based on their mortgage escrow guidelines or whatever. But when we do get an HOA reserve payment, we do post those to post petition. But let's discuss it with your counsel so that you make sure that you're posting the correct trustee payment to the correct homeowner account.
And Mary, you'll actually file something as part of
Yes.
the proof of claim for post-petition amounts, right?
Yes, generally, and it depends on if it's single family or townhome or condo, but a lot of times we'll have to go in and do 2 claims. And believe me, we only do that when we absolutely have to. Then sometimes we can follow up each year that the post-petition assessments accrue, and we can file an HOA reserve statement. Some of our clients are so advanced that they prepare their HOA reserve statements themselves. They send them to me, we review them, and then I submit them on from there, which works very well.
Are any other districts doing this, or is it just Southern?
Yes.
Still?
So other districts are doing it. The Western is really getting on board, and they do it a little bit differently, and they refer to it. I know this term applies for the mortgage, but where the HOA is involved on the reserve, Western District calls that a full conduit plan. So it's conduit of the HOA pre-petition claim, and then it also includes every year as it accrues. But what happens more likely than not in the Western District, and this is great, we can still be thankful for it, is a general understanding that these people don't file bankruptcy and then say 4 years later with 4 years of assessments due, I thought it was in my bankruptcy. There's much less of that now, thanks to this HOA reserve system, and we're working to improve it all the time. Sometimes it's very frustrating. If you have trouble with it, please reach out to your counsel so they can figure it out.
So again, the whole intent of this reserve system is to get our post-petition assessments paid, because how many times have you dealt with a darn account where you're in year 5 of the bankruptcy and you're like, but Mary, Clint, they haven't paid 5 years of assessments. Well, the courts have finally kind of recognized this and have taken some steps to try to remedy it in conjunction with the trustees for the various districts. So again, it is a good thing, and it's getting better and better every day. So we're working to try to get this pushed as well, because we don't want a post-petition account just to sit there stagnant, because we don't want to violate the state. Post-petition account we've already talked about, but please, you don't get to add attorney's fees or late fees. So any work that the law firm does on the bankruptcy, most of the time it's a cost of doing business. We do not get to recover it. Why? Because there is a rule that's especially followed in the Southern District and other districts as well. But Southern, we see it a lot more because there's a case down there. But it basically is this. If you want something other than assessments and interest on assessments, you've got to ask permission from the court. You've got to file a document asking for permission. Mary and I, we tried the filing a few times, and it has never been granted by court. They look at that and say, you know what? I've got unsecureds I need to pay. I'm not going to let late fees get tacked on when unsecureds are getting pennies on the dollar under the plan. So we don't get to levy the attorney's fees against the account unless there's a dismissal. Now, if there's a dismissal of the bankruptcy, then it's like the bankruptcy never happened. But otherwise, Attorney's fees incurred generally on an active bankruptcy are a cost of doing business. Now, that's important because our law firm recognizes that, and we try to take what's called a passive approach to active bankruptcies. That means we do not actively monitor the bankruptcy unless the client wants us to. Now, if the client wants us to and recognizes that there's going to be attorney's fees that they may never see again, well, then Mary and myself, we can actively monitor. But otherwise, we do a passive approach where we just look for big ticket items like a dismissal or a discharge. And again, sometimes we don't see those because of the whole noticing system. But again, we do that because we know that those attorney's fees may never be able to be collected. All right. Managers, deed restriction violations, what do we do? Can the management company send a violation notice for a post-petition violation? Yes. You cannot make demand for payment. You cannot threaten legal action. There's an option to do it, but it's sticky, and get with your counsel on it as an option, and then retain a copy of it. So it's, hey, we've noticed that you failed to maintain your front yard. Please maintain your front yard. We want the community to look good. Think of it like a courtesy notice that's even more vanilla in terms of threats. Retain a copy of it. Why is that important? Because if you send 3, 4, 5 notices and you give us those copies, Mary gets to go to the debtors council and say, hey, debtors council, your client's messing up. And here are the letters, here are the pictures, do something about it, or we're going to bring it up to the judge. And judges do not like to see violations on owners who they're helping to turn over a new leaf. The judge expects them to maintain their property properly. What about uncured violations? Provide your law firm with the notice and the photos, and the inspector needs to note the date. And again, provide photos, whether it's uncurable or curable. And that'll allow us, Mary, to kind of reach out to debtors council to try to get something fixed. And if it still doesn't work, and if it's a really bad violation, we can consider filing something with the bankruptcy court. And maybe we file something confirming the absence of the stay, which would allow us to file a lawsuit in civil court. Again, the lawsuit we file in civil court, really, you've got to be careful on it. There's case law supporting the idea that you can still file a lawsuit for post-petition violations, but you've got to be careful how you word the lawsuit. So,
and you have to have bankruptcy court permission first.
Exactly.
Through the motion for relief.
Yep. Proofs of claim. All right, Mary, give us a 3-minute hit on what a POC is.
Okay, so a proof of claim is the actual documentation evidencing what was owed on the homeowner's account at the time that they filed bankruptcy. And that includes not only assessments and all collection charges associated with assessments, but it also includes deed restriction violations, if there are fines, even if they're unsecured, photographs that had to be taken, anything like that. All of that is included, and it can be what's called bifurcated or separated within the claim, the secured amounts from the unsecured amounts. But the establishment of the proof of claim is what gets us in there. And it's what gets everything going, as far as even if the homeowner failed to mention their HOA debt to their attorney. And you'd be surprised how often that happens. It gets us in there. It gets the claim going. Now, it doesn't mean that we're going to be paid 100% according to the claim as we file it. We may still have to negotiate. They may have to modify it later. There are different, possible scenarios, but it is the absolute end all be all of what was owed pre-petition. And it has to be nearly perfect in accordance with bankruptcy, Federal Rule of Bankruptcy Procedure 3002.1. Now, what that statute provides is that every part of the claim must be itemized. You must have assessments. This is the amount. You must have interest. You must have late charges. You cannot put one lump sum for any categorization of the debt that provides the sum total. In other words, it has to be itemized. So we're going to come back with y'all if a lot of times you guys will take on an HOA from a prior management company and they'll just do like a dump and it'll just be one line. And we have to come back to y'all and say, I'm sorry, but we can't work with this. Can you dig up an archive box or anything? And a lot of times I'll go in and contact the prior management company myself. And I'll say, hey, do you want a subpoena to have to appear in federal court? And they go, huh? And then, we can get the information, but it has to be line by line itemization. And this is what gets us paid.
And I think Mary's final point is very important. This is what gets us paid. And if you don't file it properly, you may get paid nothing. And properly also means not including unsecured amounts as secured. You cannot call an unsecured amount a secured amount. That can get you in deep water with a judge.
Absolutely. And we had a recent one, just real quickly, we had a recent one where a couple of years ago, someone from a management company had gone ahead and filed a claim on their own. And while we understand why that might have been done at that time, real quick, get it in there like that, there were so many problems that we ended up having to remove it and replace it. So please always go to your counsel first.
All right, so Mary and I have been talking about dismissals versus discharges. This is kind of laying it out very clearly. A dismissal is as if the bankruptcy never happened. Mary, you liken it to a what is it, a what do you call it?
Don't get dissed. Like, you wouldn't want to be dissed, right? So when the bankruptcy court throws the debtor's bankruptcy case out, they're dissing them. In other words, you're out of here. You did not follow the rules. You did not make the payments. You're gone. That's what dismissal means. They were dissed.
Now that's a good thing because it is as if the bankruptcy never happened, which means we get to levy all of our interest, all of our late fees, all of our attorney's fees, and then we just have to look at where the collection case is in the process. If we're in pre-litigation, i.e. no lawsuit was filed, then the management company has to send a new 209 letter if you're single family. If you're a condo, you technically don't have to send anything unless your collection policy requires it. But you send your new 209 if you're single family, and then you refer it back to the attorney's office, and then they proceed. Now, if you are in active litigation, the attorney will just notify the court, hey, there's no longer a bankruptcy, get us off the bankruptcy docket and onto the civil docket, and then we can proceed with litigation. A discharge means the owner was successful in the bankruptcy.
Honorable. It was honorable discharge.
There we go. Honorable. So they were honorable discharge. That means they were successful. They get to turn over their new bankruptcy leaf, which means Mary is going to be telling you to write stuff off the account.
Yes.
It
oftentimes
stinks.
It does. But oftentimes we can wrangle it to where it's not so painful. But again, anytime we notify y'all of a discharge, or if y'all receive one in the mail and y'all notify your counsel, please be sure to include a full current account history so that we can go over it and we can mark out what cannot be collected after the date of discharge and what can, and then y'all can proceed. But we have to go through that process first. We call it bankruptcy closing analysis is what we call it.
Perfect. All right. On to the questions. Sorry, I tried for 15. We've got 8. Well, actually, we've got like 9, so 9 or 10 because we started around 11:32. So let's get into these. So the first question, if I have a person in bankruptcy that is on a payment plan, do I need to offer a plan for the current year's assessment? So Mary, they've got a payment plan. There's an active bankruptcy. They've worked with counsel on the plan. Everything's good. The new year assessment comes due. Can that be wrapped into the payment plan?
Certainly. And the parameters would depend on when was the bankruptcy filed, and is the pre-petition in the bankruptcy plan, or is it still being handled through the payment plan? We most often see these types of scenarios in a Chapter 7, where the debtor is not going to be in bankruptcy very long, and there won't be a payment plan through the bankruptcy court administered by a trustee.
Perfect. All right, next question. If a unit sells while the owner is in active bankruptcy, does that wipe out the pre-petition amounts owed to the
No.
association?
No, not at all. What we
Well,
do.
if you do something
Okay.
right?
Okay.
What happens?
Right.
Yeah. So Mary, if they contact legal counsel, what happens?
Yeah. So generally what we do in a case of a debtor actively selling their property while active in a bankruptcy is we look for either the bankruptcy court order that's allowing the sale, in which sometimes the judge may actually, strike out part of our balance that's owed, or they may not, or they may say it has to be paid in full. But either way, what we provide is an NREM payoff, a payoff as to the property, so that nobody can claim that we're violating the stay or that we're harassing them individually as persons, but that we're proceeding to collect the NREM against the property lien.
And you provide it to debtors counsel. You may provide a
Yes.
copy of it to the trustee as well. You do
Yes.
not provide it to the owner.
That's correct. Never provide it to the owner.
It's so important to get your counsel involved in this, because there are a bunch of hurdles that you've got to leap over. Because you do it wrong, you're going to be in violation of the stay and potentially an order of the court as well. So
Yep.
Get your counsel involved. But again, as long as you do it right, yeah, you should get paid in full, unless the judge has wiped us of certain amounts due and owing for the association. All right, so how long does a bankruptcy last? Chapter 7s, how long does a 7 last usually, Mary?
3 to 5 months generally. And what you'll notice, and we'll cover this next time in Bankruptcy 201, but what you'll notice is since COVID, bankruptcies are lasting longer. That's not your imagination. It's a little provision provided by the CARES Act. So yeah, it's not your imagination.
So typically 3 to 5, they can extend a little bit longer because of different circumstances. Chapter 13s are typically 3 or 5 year plans that can be longer. They can be longer, but typically that's what you're dealing with. Next question, Mary, we touched on this a little earlier. Can deed restriction violation letters go out? Short answer is yes, but you've got to remove a bunch of your stuff in your standard letter. You cannot demand money. You cannot threaten legal action.
Yeah.
Think of it as a courtesy letter where you're like, hey, man, clean up your stuff, and make sure to maintain copies of the letters, maintain copies of the pictures, so that if they don't fix the problem after 2 or 3 letters, you can get your counsel involved. Next question, the HOA can end up paying for oh, yep. So we hit that. Are only bankruptcy accounts split, or should we be doing this with every account escalated to legal? So no, you should not split your account that is not in active bankruptcy. The only time you split is when there is an active bankruptcy filed. And again, work with your counsel. Mary works with managers all the time on how to properly split, and accountants with the accounting department. How many times can a homeowner file bankruptcy? It seems they file multiple times, therefore the delinquent account is just prolonged for years. Why is this allowed? So Mary, you want to give us a quick response?
So just to recap what we discussed earlier with regard to 11 U.S.C. 362 Section C3 and Section C4, when the bankruptcy reform came through in 2005, again, it's not limited to the amount of times they can file. It's limited to the amount of where they file a bankruptcy and it gets dismissed, and then within a 12-month window, they file another bankruptcy. That's the structure.
So again, they're called serial filers, and if a debtor files bankruptcy multiple times, your counsel may be able to do something. I mean, Mary and I got probably 4 or 5 years ago, we dealt with one where they probably filed, I think it was somewhere around 10 bankruptcies, and it was a husband and wife, and they would use the husband's name first, and then the wife's name second, and then the husband and wife's name together, and then maybe a husband shorthand name to try to, get around this problem. And Mary and I were able to file a motion. I went up and argued it, and the judge was livid. Basically a show cause order was issued where they had to show up in court and explain to the judge why they were basically misusing the bankruptcy code. So there are ways to fight back in those instances. Next question: if the HOA has forced maintenance, can you force mow a property? Okay, so assuming the governing documents allow for force mows or force entry to do something on the property, can you do it if somebody's in active bankruptcy? Yes, you can, but you cannot charge the owner back. So can you do it? Yes. Can you charge the owner back? No. Should you get with counsel before you send something like this? Absolutely, because it may be something we don't want to do. Maybe your counsel is going to reach out to debtors counsel and say, hey man, can you get your guy to do X, Y, and Z? We're about to have to do a force mow. We're not going to bill him back, but we need to get it done. What is the difference between secured versus unsecured? So in a bankruptcy, we'll go with Chapter 13, pre-petition amounts. Unsecured amounts due and owing get treated like a credit card bill. So a credit card company may get paid 15 cents on the dollar. That means your unsecured amounts, you will get paid 15 cents on the dollar. You're treated like an unsecured creditor for those amounts. The secured amounts, which are lienable against the property, most of the time you get 100% of those amounts. So that's the difference in the bankruptcy world. And then finally, are these amounts disclosed on a resale certificate? Again, if there is an active bankruptcy, get with your counsel. Yep. Mary, myself, for those accounts with us, we'll do a deep dive and we'll make sure the resale certificate is making a fair representation to the trustee, the bankruptcy court, and debtors counsel. All right. Any other questions? Well, hey, thank you all so much for joining Mary and I this morning. I know bankruptcy is a tough subject, but I hope it wasn't too boring. Again, any other questions, you're always welcome to reach out to myself or Mary Shiloh. Mary, anything else to add?
Yes, this is so much fun. I can't wait to do it again. Are we going to do a Bankruptcy 201?
I think we're doing one soon. Well, hey, y'all enjoy the rest of your day. And again, we've got a Bankruptcy 201 next week, which kind of delves in a little bit deeper. Otherwise, y'all enjoy your afternoon. And if you're still without power, I'm sorry. Y'all be safe, and hopefully we'll get back on our feet after last week's Ice Mageddon. Bye, everybody.
Bye.